bill in this committee. Allow me to tell us where we left off from the last meeting. Last May 11, we were able to insert new terms in Section 3, such as marginalization, which refers to a condition where a whole from useful and meaningful participation in political, economic, social, and cultural life, as suggested by the UPGLPP. And intersex, that refers to people who are born with physical or biological sex characteristics that do not fit the typical definitions for male or female bodies. For some intersex people, these traits are apparent at birth, while for others, they emerge later in life, often at puberty. This is courtesy of the Office of the High Commissioner on Human Rights. The members have voted in favor of retaining the term gender identity in the entirety of the bill, with votes cast at 13 for the retention and 1 against. Hence, the term forms part of the bill with some amendments taken into consideration. It is now defined as referring to a person's innermost concept of self as man, woman, or another non-binary identity which may or may not correspond with their sex or gender assigned at birth, and may be as characterized, among others, by manner of clothing, inclinations, and behavior in relation to masculine or feminine conventions. A person may have a male or female identity with the physical characteristics of opposite sex. It was also held by the chair that the terms religious affiliation or belief converted and religious expression will be included, and both will have separate definitions. The committee will begin its deliberations today in Section 5, Paragraph G, on the denial of the right to access to places, facilities, and modes of transportation for public use, and to attend meetings open to the public. In presiding over this meeting on behalf of the chair, who will be joining us sometime soon, I'm assuming, I hope that we can be as productive in our discussions on this very important and landmark bill for the Committee on Human Rights. After all, the bill conveys one aim articulated in the Charter of the United Nations, of which we are a founding state member, and that is to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small, and to achieve international cooperation in solving international problems of economic, social, cultural, and humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinction of race, sex, language, or religion. At this stage, I would like to recognize the members of the committee that are here present with Congresswoman Castro, the Deputy Speaker Lito Atienza, Representative Geraldine Roman, one of the authors, Representative Luisa Quaresma, and Representative Sara Ilago. ComSec, may I ask you to recognize the resource persons present today?
Yes, sir. Good afternoon, Your Honors. For today's meeting, we have in attendance the following resource persons. From the Commission on Human Rights, we have Attorney Gemma Parahinog. From the Department of Justice, State Counsel Attorney Shiara Mangoba. From the National Commission on Indigenous Peoples, Ms. Adrienne Regine Dunuan. From the Philippine Commission on Women, Ms. Josephine Kalin Sasuman. From Legal Aid Ministers and Partners, or LAMP, Mr. Moises Rivera. From CBAC, Mr. Anthony Roquel. And Reverend Bishop Ruben Abante from Lighthouse Bible Baptist Church. And Attorney Alexa Salugsugan from UPGLPP. That would be all, Your Honor.
Thank you. Thank you for joining us today. And yes, you know, the previous 4 sections have benefited from the intense discussions we've been having as we try to refine this House bill. ComSec, can we start then with Section 5, letter G of the bill, of the substitute bill?
Yes, sir.
Okay, so continuing with our discussion from last time, letter G reads as follows: denial of the right to access places, facilities, or transportation for public use, and to attend meetings open to the public. Any principal or agent shall be liable for discrimination as exercised through acts such as the following. One, refusing to allow another person access to a place, facilities, or any mode of transportation that the public or a section thereof is entitled or allowed to enter or use. Number two, refusing to allow another person access to or use of any such place, facilities, or any mode of transportation by providing onerous terms and conditions not similar to others whom they would otherwise allow access to or use of the place, transportation, or facilities. Is this so far acceptable to everyone? Number three, refusing to allow another person access to a meeting or assembly open to the public or to a section thereof, or refusing to allow another person access to a meeting or assembly by providing onerous terms and conditions not similar to others to which they would otherwise allow access to a meeting or assembly. And number four, requiring another person to leave or cease to use any such place, facility, or any mode of transportation. Is this acceptable to all our authors and representatives present? Any comments from our resource persons? Uh, yes, Miss Salugsugan, you are recognized. You are muted though.
Hello, can you hear me,
Yes,
Mr.
ma'am.
Vice Chairperson? Okay. Thank you, Mr. Vice
Yes.
Chairperson Benitez. Good afternoon, Your Honors. I am Alexa Salugsugan of the UPGLPP, and on behalf of our Program Director, Professor Batad, I will be presenting our institution's comments on the provisions of the Comprehensive Anti-Discrimination Bill. Before I begin, I would like to thank the House of Representatives Committee on Human Rights for giving us once more this opportunity to be a resource person in the drafting of the substitute bill on the CADB. So for this provision on denial of right to access public places, we would like to propose for the consideration of the committee a similar provision which we proposed to subsection F of section 5, which is the above-mentioned acts or omissions under this provision shall also be discriminatory when they are committed against juridical persons on the basis of the actual or perceived protected attributes of their members, officers, board of directors, and trustees, or their target constituencies. So as we have said before in the previous hearing about this provision, we propose this in order to address acts of discrimination which may be committed against juridical persons, such as organizations, associations, or nonprofit institutions composed of, representing, or catering to members of a particular vulnerable community on the basis of their protected attributes, such as those of their members or of their target constituencies.
Comsec, can you please note the proposed intervention? I would also like to recognize the arrival of Representative Abueg Saldivar. Good afternoon, Deng.
Hi, Chairman. Hello po to everyone.
Yes, sir.
Comsec?
Yes, sir. Noted on that proposal, sir. But
Is
in
this
their
acceptable
position,
to the... Yes, go ahead, Comsec. Sorry.
sir, clarification lang po. Because in their position paper, that particular proposal is being suggested under paragraph F. So, are you also proposing that for paragraph G, sir?
Mr.
Ms.
Vice
Alexa?
Chairperson, may I speak? Yes. Of ComSec Parcon, yes, we are also proposing the inclusion of this subsection in subsection G.
Okay, noted.
Okay.
Thank you.
Can I continue lang with the rest of the subsection G, so we can complete it, Comsec? Number 5 was failing to make reasonable effort to make facilities accessible to people whose disabilities reduce their range of mobility or communication. And 6, subjecting a person to denial of access to public places, public facilities, public transport, or public meetings. There's a proposal for the inclusion of the provision again to protect juridical persons. Acceptable to the present Congresswoman Roman? Is she? There's a comment from the DOJ.
Good afternoon,
Ma'am, you are recognized?
Yes, sir. Thank you, Mr. Chair.
Yes.
First, we apologize for the late transmission of the position paper of the department. May I confirm with COMSEC if the committee already received the copy of the signed position paper of the department?
Mr. Chair.
COMSEC?
Yes, attorney. Yes, attorney, we have received your email on May 18.
Okay. Mr. Chair, with respect to our position paper, we note that we have our position paper still includes comments on sections already discussed in the previous meetings. However, we submit to the wisdom of the committee and the members of the committee if they would still be considering the comments of the department. With respect to section 5, Mr. Chair,
Yeah, letter G.
For the entire section, Mr. Chair, may we make a general or omnibus comment that all these acts considered to be discriminatory should be considered discriminatory only if made on the basis of protected attributes as defined in section 3. So for example, in section in letter G, if Ma'am Comsec, if can we go to the introductory heading of section 5G? In this, Mr. Chair, it only mentions that shall be liable for discrimination as exercised through acts such as the following, but if we may make a suggestion that in order for these acts to be considered discriminatory, to be prohibited under this bill, it should be based on discrimination based on the protected attributes, Mr. Chair.
COMSEC? Isn't it clear
Yes,
in
sir.
the previous section that these discriminatory acts are premised upon the protected attributes mentioned or defined in the bill?
Yes, I believe so, sir. Under the first paragraph of section 5, the protected attributes have already been enumerated. So the understanding is that we recognize the protected attributes to be
The
respected.
basis.
Yes, to be the basis.
So,
Attorney,
yes,
I-
if that's the case, may we make the manifestation that our position paper is based on the previous drafts of the comprehensive bill. So when our position paper was drafted, the section 5 still has no reference to the acts as discriminatory based on protected attributes. So you will see if you can go over the position paper of the department, there will be comments on certain sections that will mention that the act should be based on discrimination against protected attributes, Mr. Chair.
yes, ma'am. COMSEC, Comsec, you can go back to the first paragraph of Section 5 just to alleviate the concern of the DOJ.
Okay po, sir. Page 9, Hansel.
Thank you, Mr. Chair.
Ito, ma'am, ito po. Discrimination is committed when a person treats another less favorably on the basis of actual or perceived, and there's a whole list of all of the protected attributes that are actually mentioned, I believe, in the bill.
Thank you,
Would this suffice?
Yes, Mr. Chair.
Okay, thank you, Attorney. Can we go back down then, Comsec Felly? Hello? So if there are no comments on letter G, we will continue with letter H. The denial of access, of right to access or publish advertisements in mass media. Any person acting as principal agent shall be liable for discrimination as exercise, publishing, displaying, or causing or permitting to be published or displayed an advertisement or notice, including access to social media, that indicates or could reasonably be understood as indicating an intention to do an act that is unlawful by reason of a provision of this act. Are there any
Mr.
comments to this provision? Yes, Bishop Abante. Bishop Ruben,
Yes,
yes, sir.
I'm
You're
sorry, I just
recognized.
have to go back a little. I noticed that the word onerous is once more being
Yes.
repeated in the provision. May I simply ask, would this be the best term that can be used? Or can we just, because this is anti-discrimination, siguro yung word na oppressive rather than onerous? I'm just looking for a better term.
Comsec, what was the decision previously on the term onerous? Because that was also actually discussed in on May 11 in terms of being very difficult to evaluate what constitutes onerous, which I think is what Bishop Ruben is pointing to. Ano yung decision
Yes,
natin
sir.
lahat?
Sir, last time we deleted the word onerous and retained terms, but I've also added and conditions just to be consistent with the other paragraphs which have that word, sir. So the phrase now is terms and conditions.
Okay, can you go back then to the section above that Bishop Ruben is referring to? Taas pa ng konti.
Section 5A.
Ayan, ito.
Paragraph
Number 2,
2.
for example.
Yes, sir.
Oop. Nababa pa. G, number 2. Sige pa. Ito. By providing onerous terms and conditions not similar to others in number 2. Comsec, what was the new language that was from last meeting? Because I think just to be consistent, perhaps we should just use the same terminology.
Yes, sir. We will edit accordingly, sir. Maybe at the last, at the
So
final
both
draft,
2 and
sir.
3, no? Sige, ano na lang, just mark
Omnibus na lang, sir. Yes, sir.
it.
Yes, sir.
Just mark it. So sa 2 and 3, for example, tama si Bishop Ruben.
Thank you, Mr. Chair.
Comsec?
Mr.
Thank you, sir,
Chair.
for
Yes, sir.
signaling us.
Thank you po.
Sorry, who is
Yesenia
speaking? Sorry.
Kayamat, Mr. Chair.
Hi, Kafemia po. Yes, ma'am.
Mr. Chair. Gusto ko magmanifesto doon sa section 5, letter F. Yung denying accommodation against refugees, evacuees, and internally displaced persons by reason of natural tragedy, tragedy and armed conflict na is pong magpahayag ng ating manifesto.
Can you go down, ComSec, to the section that Kafemia is mentioning?
Section 5, letter F. Yung denial of the rights to reasonable accommodation. Yan.
Paragraph 5, Hansel.
Ito.
F, I, 3I. V tapos 3I.
8. Section 8. Baba pa.
Section 8.
Bullet number 8.
Taba.
Denying accommodations. Ayan.
Ako po yung sumusuporta ng provision ito. Lalo na ito ay nararanasan ng mga katutubo kapag sa pilitang magbakwit. Example nito yung bakwit sa Haran kung saan pilit na pinapalayas ng LGU ang mga lumad sa sanctuaryo. Kaya ako po ay sumusuporta sa provision ito, Mr. Chair. Maraming salamat.
Salamat po, Kafemia. Meron pa po ba tayo? Or we could the next section?
Mr. Chair,
Thank you, Kafemia.
this is
Yes, Ma'am Gemma.
from Commission on Human Rights. Regarding the same provision,
Yes,
we
ma'am.
just recommend to change tragedy to calamity. That's the two causes of internally displaced persons, natural calamities and conflict, armed conflict.
ComSec?
Yes po, sir.
Thank you, Ma'am Parohinog. Can we proceed? Sa baba. Sige pa. Sige pa. Okay. Denial of right to access or publish. Any interventions on this provision? None? We will continue. Letter I. Sorry. Yes, Miss Salugsugan. You are on mute, ma'am. Hindi ka namin madinig. We can't hear you, but I see I can see the in the chat the intervention, which is to create or to make employees of the board of directors or trustees part of the liability for discrimination. Tama ba? In other words, the juridical. Say you're on mute. Yen. Wala pa rin. Would Steph Agor want to speak?
Hello, good morning po, Representative Benitez. The UPG
Yes.
would like to propose the inclusion. Our inclusion is the one in capital letters. Any person acting as principal or agent, including employees, officers, board of directors, or trustees. And in the last clause, including or excluding persons from access to social media.
Ma'am, can I ask a question about the including of employees? That first section, that first section, as principal or agent, including employees, officers, board of directors. You're saying any above agents. Ganun ba?
Sorry, Representative Benitez, you got choppy po towards the end.
Sorry. My own internet is not so good. The Are you suggesting then that principal or agent can include any of these categories on employees, officers, board of directors, or trustees? And you're basically clarifying it.
Yes, Representative Benitez. The reference provision is from the House CHR final draft and is amended to expressly include in the enumeration of persons liable employees, officers, directors, or trustees. This enumeration is based on the liability of the agents of a corporation under the doctrine of apparent authority. And
Okay. And then the next one is to excluding from access to social media.
Yes, Representative, we would like to
Okay.
include this in order for greater clarity and to emphasize that the prohibited acts here and can also be perpetrated and done in social media.
All right. Is this any comments from the authors or the members of the committee? All right. In which case, shall we continue? ComSec. Denial of right against wrongful portrayal. Any person acting as principal or agent shall be liable for discrimination by portraying, intimating, depicting, or describing in learning institutions, instructional materials, teaching devices, books on reference materials, especially in civics and history, certain individuals and or groups as inferior. Am I assuming that you will add including employees, officers, board of directors, or trustees as well here in terms of principal or agent, or is that no longer necessary, Ms. Steph Agor?
I am sending. Ms. Salugsugan would like to speak.
Hello.
Ayan. Okay.
Hello.
Yes, we can hear
Yes.
you now.
Thank you, Mr. Vice Chair. I think it was my earphones earlier. I'm so sorry for that. So for subsection H, I would just like to clarify that we wanted to include the enumeration because it was our interpretation for subsection H that this provision is something that can be committed by mostly by a juridical person because it says here denial of right to access or publish advertisements or mass media. So from our interpretation of this provision, we thought that the intent of the law was to penalize those who are preventing persons of who belong to a particular protected attribute or vulnerable group to access social media or to publish such things as advertisements. So perhaps for the next subsection, such as denial of right to wrongful portrayal, this enumeration would no longer be necessary because wrongful portrayal can be committed by both natural and juridical persons.
Okay. So add the same to this section. Tama ba, Alexa?
It is our view that it's not absolutely necessary for subsection I. But perhaps we can get more clarity on the intent of subsection H.
No, okay na yung subsection H. I think that clarity in subsection H is okay. But you have here,
Mr. Vice Chair.
Yes, ma'am.
May we also, since we are also already in subsection I, may we also include one of our proposals for the consideration of the committee in letter I?
Yeah.
So for letter I, in denial of right against wrongful portrayal, the UPGLPP makes three observations. So for the first paragraph, we propose to include after the word history and in mass media, comma, including social media. And this is to expand the scope of the provision, not only to publish traditional materials or media, but also to the evolving spaces that we have on the internet, such as social media. Furthermore, we would also like to include the words encouraging the commission of any of the acts of discrimination against any person or group, because wrongful portrayal, in our view, is not just committed by describing or depicting discriminatory attitudes, but it can also be committed through materials or narratives that actively encourage discrimination, which may influence others to commit it. And finally, we would also like to include a proviso that would balance the interests of free speech with what constitutes wrongful portrayal. So for this, the GLPP proposes the Miller versus California test, which was also cited by our own Supreme Court in Soriano versus LaGuardia, so that we can determine what is a reasonable standard in determining whether a certain portrayal of a vulnerable group would still fall within the ambits of free speech. So for this, the test that we propose is whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. Thank you, Mr. Vice Chair.
Comsec, I think dito muna ang in civics and in history and in mass media, including social media, yeah, as inferior, or encouraging the commission of any acts of discrimination against any person and or group as provided in this act. Nasa chat, Comsec, Feli, ang proposal nila. Are there any objections from any of the members? Any other resource persons? So it shall read, or encouraging the commission of any of the acts of discrimination against any person and or group as provided in this act, provided that the test to determine wrongful portrayal should be whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. Can I recognize the NCIP, please?
Yes, good afternoon, everyone. Good afternoon, Vice Chair. This is Adrian from the NCIP. Just a minor change lang po. Though yung second paragraph, lines 23 to 26, this is a recommendation also from the NCIP, but baka po mas proper itong paragraph na to on the provision on IEC, which is section 13. Kasi yung previous provisions pertain to prohibited acts. Pero ito kung more on IEC provision po ata to in second paragraph. So that is just our minor recommendation lang po to transfer
to transfer
this
section,
yes,
so that it is not part of the prohibited acts but in the encouraged acts further down. Tama ba ako, ma'am? Yun po ang suggestion.
Yes po. Yes po, sir.
Okay.
Thank you, sir.
Comsec? Thank you. Any other comments on this section of letter I? There being none, we'll continue. The denial of the freedom of speech, utterances, acts of hatred, and similar acts. Any person shall be liable for discrimination exercised through delivering speeches or making utterances, doing acts of hatred or violence against another person, or mocking or ridiculing another person on the basis of ethnicity, race, color, sex, gender, sexual orientation, gender identity, gender expression, sexual characteristics, language, religious belief or expression, political or other opinion, national or social origin, property, birth and other status, and other protected attributes, including disability, age, nationality, marital and family status, health status, place of residence, economic and social situation, maternity and pregnancy, provided that the freedom of speech and of expression shall not be abridged, and the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. Is this acceptable to everyone? Are there any comments to this? Alexa, salugsugan?
Thank you, Mr. Vice Chair. So for this, the UPGLPP is actually proposing that the proviso on free speech and religion is proposed to be deleted because these are self-executing provisions under the Bill of Rights which are enforceable on their own even without an enabling law. So the plain meaning of the said rights to freedom of religion and freedom of expression leaves nothing more for their enforcement, and in our view, it does not require an enabling law because the Constitution, by its express terms, already prohibits all kinds of state action from all branches of government abridging freedom of speech or the free exercise of religion. So for this, we are proposing that the provided that clause should be deleted.
Okay, thank you. Ms. Paronghinog, please.
Thank you. I agree with the suggestions of UPG, LPP, except that we would like to also recommend the removal also of the mentioning of the protected attributes. We can already mention that the same be stated as on the basis of the protected attributes as identified or defined by Section 4. Instead of putting everything again here in this section.
Understood. Bishop Abuan, you were going to say something, sir?
I just wanted to agree with what was said concerning the reference to religious expression.
Okay.
Yeah.
Ma'am Adrian Dunuan of the NCIP, did you have your hand raised?
Sorry, by mistake lang yun.
By mistake. Okay. So we have two proposals. One is to remove COMSEC, the long enumeration of protected attributes, and simply cite the protected attributes already defined in the Act for brevity's sake. And the second one is to remove the provided that freedom of speech and expression because it is given already as a constitutional right and need not be repeated. Is this acceptable to all the committee members present? Any interventions? All right. Kafemia, may sasabihin ba po kayo?
Okay na po, Mr. Chair.
Okay, thank you. COMSEC, then let's continue down.
Mr. Chair?
Bishop Ruben, yes po.
I just have one more concern. Situational lang po ito, no? After having, naiisip ko lang ito dahil doon sa words na political, lalo doon sa wrong portrayal. Just a situation. We're coming into a period of election. What if I would be present in a forum publicly and I would be asked, ang tanong siguro sa akin, what do you think of this candidate? What if I answer like, I do not think he has that competence for such a position? Would I be guilty of discrimination?
Balik mo doon, COMSEC, sa section na yun. Sige, akit mo pa ng konti. Right? Because I think...
Kasi may nakalagay, political and opinion eh.
Oo. Ano ho eh, you have to ridicule, di ba? You have to be encouraging discrimination. I don't think evaluation is the same as discrimination in this case, no? Okay. So if we move up a little bit, I think part of the fear, no, has to do with portraying as inferior.
Yes, yun isa pa yun.
Which might be insufficient descriptor. Asa na ba to? Akyat mo pa. Access yan eh, di ba? Sige pa. Akyat mo pa ng konti. Hindi. Sorry. Down. Back down. Okay. Certain individuals and or groups as inferior, di ba? So ang concern ni Bishop Ruben is, for example, if in my evaluation of political candidates, for example, the term inferior becomes part of
Yes.
my evaluation, but it is not necessarily a push towards acts of discrimination. Is there an ambiguity in the law as proposed? Tama ba po ako sa concern that you brought
Yes,
up,
opo.
Bishop Ruben?
Tama po.
I think si Miss Sulugsugan has a suggestion, ma'am, to get us out of that quandary.
With regard po to Bishop Ruben's comment, actually, that is why we need to have a test in this provision that will make it easy for the courts, for example, if it ever comes to that, to ascertain whether the portrayal involved is still within the person's free speech. So, tulad po ng sinabi ni Bishop Ruben, if for example, as an individual, he's expressing his opinion about a particular political candidate in the context of a political debate. So if we have this test that we are proposing, we should take the context of the portrayal as a whole and ascertain whether the work as a whole lacks serious literary, artistic, political, or scientific value. So in that sense, if in the context of a political debate, then we can say that there is serious political value in that because it's a political debate. But if, for example, the portrayal involved is merely derogatory or obscene, or it's it's merely derogatory against a certain individual or person, then we can say that it doesn't actually have serious literary, artistic, or political value that can already count as wrongful portrayal. So yun lang naman po.
Bishop Ruben?
Well, I'm just concerned kasi yung ambiguity kasi nung provision might end up, alam mo tayo mga Pilipino minsan sumusobra yung pag-uusap natin Yung may sakit dito sa kabila, patay na Ganun tayo palagi. So hindi natin alam kung saan pupunta yung usapin na yan. Yun lang po.
Sige, sir. No, but the response, I think, is that the added provision about the test to determine wrongful portrayal is given so that the concern that you have about value or evaluation can be addressed by the determination of wrongful portrayal test. Yeah, or at least it should. Can we continue, ComSec? The denial of the right to health and well-being. Any person shall be liable for discrimination exercised through subjecting any person without full, free, informed, and prior consent to any unnecessary medical or physical examinations, psychological treatments, faith-based practices, or other similar procedures that aim to change identity or physical attributes or impose behavior or expressions. This shall include denying a person access to public or private medical and other health services open to the general public, as well as access to public and private health insurance, including health maintenance organization provided medical plans on the basis of the grounds referred to in this act. Is this acceptable to everyone? Can we move on then? Letter I. Denial of right against profiling. It shall be illegal for any person, including members of the police, military, and uniformed personnel in government service, to engage in profiling based solely or partly on the grounds included in Section 4, provided that this is not to prevent law enforcement officers from acting on characteristics found in positive descriptions of suspects by witnesses. Provided further that for the purposes of this section, the purposes of profiling include investigation, insurance, and other forms of profiling which have the intention or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of political, civil, economic, social, or cultural rights. Is this acceptable to everyone? If so, shall we continue with the next section? Yes, Lexa.
Thank you, Mr. Vice Chair. So for profiling, Mr. Vice Chair, we would just like to express our concern that the first proviso on this is not to prevent law enforcement officers from acting on characteristics found in positive descriptions of suspects by witnesses. The GLPP's concern here is that it may be unconstitutional because it widens the standard applicable to law enforcement and may open this provision to possible abuse. So currently, under our Constitution, law enforcement need to operate on the basis of probable cause and not merely positive identification, meaning that there must be other tangible and credible evidence for the basis of their suspicions and not merely on the fact that someone belongs to a particular vulnerable group. So it is our view that if the only evidence being considered is the fact that someone is from a particular vulnerable group, which is essentially what profiling does, then there is insufficient information to constitute probable cause, and this will therefore be unconstitutional. We can also apply this not just in the context of SOGSC, but also in the wider context of human rights, such as for persons belonging to ICC or IPs, or those of a particular political affiliation, among other vulnerable groups.
I think the intent here, though, Alexa, is the fear that you have has to do with what acting on characteristics means. Correct? In other words, they cannot make arrests based simply on a positive description, but they need to do so based on probable cause, an investigation based on probable cause. Tama ba ako?
Yes, Mr. Vice Chair. That is because if, for example, someone positively identifies another person as belonging to a particular vulnerable group, and that is the only thing that law enforcement have to go on, and yet they still arrest someone or detain someone, then it may be that is not allowed under our Constitution because our standard for an arrest is to arrest based on probable cause.
But I think the question here is not to do with arrests, right? The question here is whether or not they can use profiling as a tool to look for or search for that person. I don't think it precludes the need for justifiable cause in order to make an arrest. Yun ang pagkakaintindi ko sa provision. I'm not sure it goes so far as to go beyond the constitutional protections, but I could be wrong. Does Ms. Paruinog have an opinion on this?
For this, sir, we do not have a comment on this unless my commissioner, who's also present, has opinion. But for now, the commission does not have. I mean,
right.
We don't have a position on this matter.
Yes, Alexa, you were going to say.
Yes, thank you, Mr. Vice Chair. So for this, actually the position of the GLPP is that profiling is inherently against human rights because it's basically allowing a person or entity to base their suspicions or to base their observations on on someone or a person possessing a certain protected attribute. So this might already be discriminatory since it will allow capricious use of the military and police surveillance and operations against vulnerable minority groups.
Can I hear from the DOJ, please? Attorney Mangoba?
Mr. Chair, may I read from our position paper?
Yes. About this specific provision, ma'am.
Yes, Mr. Chair. We have, however, we correlate our comment on this paragraph with the I'm not sure if it's still paragraph N, Mr. Chair, but it pertains to the denial of the right against illegal detention and confinement. We make the correlation, Mr. Chair. Um, we state in our position paper that the proviso in this paragraph appears to refer to criminal profiling and is deemed permissible, notwithstanding allusions to protected attributes, which may assist in narrowing down the suspects for a crime being investigated if based on positive descriptions of witnesses. Thus, despite references to possible race, physical features, economic status, age, or language, the witness averring the same and the law enforcement agent or authority acting thereon cannot be considered as violating this act. Um, with respect to the denial of the right against illegal detention and confinement, the same should follow the same principle embodied in this section or in this paragraph to afford protection to law enforcement authorities who act on the strength of the information at hand, and to the witness who merely noted the distinguishing features on the belief that the said features sufficiently limit the population to be studied in relation to a crime under investigation by the law enforcement agencies. That's it, Mr. Chair.
Mr. Chair.
How do you, yes, Bishop Ruben.
Mr. Chair, I'm not a lawyer, but the way I understand, profiling is not arrest. Profiling is helping to investigate. Ibig sabihin, like, since last year, we have been having people profiled to be PUIs. You know, alam din nila na PUI sila. So, pag na-profile ka as a PUI, you are already being investigated. Ganun lang yan sa COVID cases eh. So, profiling din naman yun eh. Pero there is already the premise that an investigation is being made. You're not being arrested. So, hindi ba ganun lang yan?
Tsaka at the same time, Ma'am Alexa, how do you read the first proviso with the second proviso? Does the second proviso not protect you from the fear that you have about the first proviso?
For the second proviso, I think as it reads now, it is just an enumeration of the purposes for which profiling can be done. So it can include investigation, insurance, and other forms of profiling which have the intent or effect of nullifying or impairing the enjoyment and exercise of civil, political, economic, or cultural rights. So
correct. So doesn't that address the fear that you have vis-a-vis profiling as being the basis of a violation of constitutional rights?
We are just concerned, Mr. Vice Chair, that the first proviso might open the law to constitutional attack because we think that it expands the standards under the Constitution for law enforcement agencies. We believe that when a law enforcement agency is profiling a certain vulnerable group, for example, for commission of certain acts, but there's no other evidence to go on aside from the fact that they belong to that particular vulnerable group, we believe that that's already inherently discriminatory.
Can I recognize Mr. Rivera from LAMP?
Good afternoon, Mr. Vice Chair, Attorney Moses Rivera from the Legal Aid Ministers and Partners. I believe the proviso is very specific. It's very particular. It's not open to any ambiguity in terms of interpretation. It just merely states that it does not prevent law enforcement officers from acting on characteristics made by witnesses. It's a positive description made by witnesses. So, for example, I think this would apply if, for example, the police would ask witnesses, what did you see or who did you see? And if a positive identification is made, for example, nakita namin na bakla, for example, or nakita namin na igurot, or nakita namin na aita, or nakita namin na pare, it doesn't really go down to the extent that the statements made by the witnesses would be discriminating or would be a form of discrimination. It just excuses those statements as a mere description, but not a statement of discrimination for witnesses, and that law enforcement officers can act based on that. Kasi if it's a form of discrimination then or profiling that is discriminatory in nature, then it prevents law enforcement from acting on it. And I believe that, as you have said, Mr. Vice Chair, there is sufficient safeguard from the Constitution. Yes, this may come into contradiction with the Constitution, but it's a constitutionally guaranteed right. So if this is a law and that is the Constitution, then the constitutionally provided right is upheld. So I don't think there would be a kasi I think if we would be more stricter in this proviso, then I think ma-handicap naman po yung ating mga law enforcement agencies.
Thank you, Attorney Rivera. Did Commissioner Karen Gomez-Dumpit want to add an intervention?
Thank you very much, Your Honor. We tend to agree with the last speaker. It does refer to profiling, which we recognize as a legal act on the part of law enforcement. And we do believe that there are sufficient safeguards. And it does not refer to arrest anyway, which should be the basis for the basis for that is probable cause. And I just would like to add, just for purposes of information, maybe what we can do is decouple profiling based on prohibited grounds versus criminal profiling, which is really allowed in law enforcement. So when you say profiling based on stereotypical assumptions, let's say based on race, for instance, color, ethnicity, or based on a certain protected attribute alone, as opposed to criminal profiling, which actually relies on actual behavior, kung ano yung ginawa ng tao. But again, if this is based, let's say, on actual witness accounts, if they are pursuing a person who has committed a crime, for instance, and this fits the description, then it is allowed within the purview of the law or the law that we're trying to propose here. Thank you, Your Honor.
Thank you. Ms. Alexa.
Thank you, Vice Chair Benitez. With that, we agree with the position taken by the Commissioner that there has to be a distinction between illegal profiling and criminal profiling, because the illegal profiling that we are seeking to criminalize here in this entire provision is when law enforcement agencies act merely on the basis of someone possessing or being part of a protected attribute or a vulnerable group. So in that case, that is what we are seeking to guard against by making our reservation. Thank you, Mr. Vice Chair.
Yeah, thank you. So, Commissioner Karen, do you have language that we can add on this proviso, for example, to clarify exactly what you have indicated?
Well, I haven't really thought about that yet, but maybe we can give a formulation in a little bit. I'd like to just confer with, ang hirap kasi po ngayon, puro electronic ang ano namin ang huddles. So maybe we can provide language for that one. Thank you.
Thank you.
Maybe
language along the line of that does not prevent law enforcement officers in criminal investigations or however you wish to.
Or Your Honor, just make that distinction between what is allowed profiling and what is not. Yung distinction na lang naman.
Hintayin na lang namin, ma'am, yung proposal ninyo.
All right.
To make it clearer. Can we move on then, or does Attorney Rivera want to say something else?
I'm sorry, I just forgot to lower my hand.
Thank
Sorry,
you.
Vice Chair.
So, letter M, no? Denial of protection against inflicting stigma. It shall be unlawful for any person to commit any act that promote and encourage stigma based on the grounds referred to in section 4 hereof. Content in all forms of media, including social media, in educational textbooks, or in any other medium that aim to inflict stigma is likewise prohibited. Is this acceptable? Are there comments on it? Yes, Miss Alexa.
Mr. Vice Chair, we would just, as a GLPP, would just like to include for the consideration of the committee as to denial of protection against stigma. Perhaps we can include, aside from promoting or encouraging the acts of inflict or perpetuating stigma, because we believe that stigma and harmful stereotypes against persons belonging to vulnerable groups are not only reinforced
Already
by
exist.
promoting or encouraging them. So
Yeah.
we can also reinforce stigma by directly inflicting or perpetuating them against a person or group. And we have also observed that the acts of inflict and perpetuate are also included in other anti-discrimination legislation on the right to protection against stigma. So we believe that by adding this, it would make the law consistent to the other legal formulations that we already have if we have this enumeration. We also think that this is in line with the policy of spreading awareness and sensitivity across all media to the end that no one should be dehumanized or devalued merely on the basis of their being part of a protected attribute or a vulnerable group.
Okay. I think that's acceptable, Comsec. It shall be unlawful for any person to commit any acts that promote and encourage, inflict, or perpetuate stigma.
Yes, sir, we will.
Nasa chat yung kanilang proposed language.
Yes, sir, we will amend that.
So, thank you. Okay. Shall we continue to letter N? The denial of right against illegal detention and confinement. It shall be unlawful to detain and confine a person or a group of persons based directly or indirectly on grounds under section 4 hereof. Yeah? Commissioner Karen, is this acceptable? Okay. Shall we move on? Discrimination through analogous acts that result in impairment of the enjoyment of human rights and fundamental freedoms. Any person acting as principal or agent shall be liable for discrimination by analogous acts which have the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise of a person's human rights and fundamental freedoms pursuant to existing laws are prohibited. There seems to be no debate on this one. Shall we continue, Comsec? Section 6, inciting others to commit acts of discrimination. Any person acting as principal or agent shall be liable for discrimination by inciting others to commit discrimination or any action that is unlawful by reason of a provision of this act, or by assisting or promoting, whether through financial assistance or otherwise, the doing of such acts or such an act. Any comments, interventions, questions? ComSec, Section 7. Protection against abuses by state and non-state actors. It shall be unlawful for any government agency, including local government units, police, military, and immigration, to harass verbally or physically, to curtail freedom of movement, or to extort from a person or a group of persons on the basis of the grounds stipulated in Section 4 hereof. This prohibition applies to similar abuses committed by non-state actors. Okay, Section 8. Sorry. Alexa, before we move on, Alexa, sa
Thank you,
lugsugan,
Mr.
please.
Vice Chair. For this, we would just like to propose a change in the item title and also in the word non-state actors, because it is the view of the GLPP that we should change state or non-state actors to government or private persons to simplify the provision and remove confusion, as the term non-state actors and state actors have different implications in international human rights law. So under international humanitarian law, the term state and non-state actors or entities are relevant in the context of attributing responsibility for internationally wrongful acts. And this section only means that both public and private persons can incur liability. So it doesn't have any reference to international law.
Granted. ComSec? Please
Yes,
note
sir.
the intervention. Section 8. Exceptions. Any action or conduct otherwise prohibited under Section 5 of this act shall not be unlawful and shall not be considered discrimination. A, where any of the protected attributes are bona fide occupational qualifications reasonably necessary to the normal operations of a particular business, or where the differentiation is based on reasonable factors, such as genuine occupational qualification. Ms. Salugsugan.
Sorry, Mr. Vice Chair, I think I just didn't lower my hand.
Okay. Are there any comments on this provision? Yes, the Commissioner Karen first, and then the DOJ Attorney Shiara.
Thank you, Your Honor. Just in reference to a specific provision also under the proposed bill, regarding our concern on non-discrimination in academic institutions to protect students from discrimination on the basis of gender expression. So maybe this is where we can make that particular distinction of sectarian and non-sectarian schools, and then public education institutions. So maybe it could be here, maybe it could be in that particular section under where was that? I think section 8 under exceptions. So what we have here is under letter E, where sectarian, educational and training institutions and institutions of higher learning. So we also want, yeah. Wala pa ba tayo doon?
Commissioner, wala pa tayo doon. Nasa letter A pa lang po tayo. We will get there.
All right.
So I will call you again when we get to that section.
Thank you.
Thank you. Attorney Yara,
Mr. Chair,
are you okay with the section A and section B?
Sorry, Mr. Chair. Gaya po ng comment ninyo kay Commissioner, I will postpone po yung aking comments after yung rundown po ng mga paragraphs dito, kasi I might be preempting the other paragraphs, Mr. Chair. Thank you.
Thank you. On that note, I would like to recognize and welcome Chairman Bong Suntay to the Zoom. Chairman Suntay.
Thank you very much. Thank you very much, Prof. Kiko.
And I will very gladly hand over the presiding duties back to the chairman of the committee. Thank you very much, Chairman Suntay.
Kiko, maraming salamat. Okay, can we proceed? Nandito tayo, section B. Any comments on section B? Okay, kung walang comments sa section B, we will proceed with C. Where the acts or practices of a body established purposes conform to the doctrines, tenets, or belief, values, and principles of the relevant religion, or that such acts or practices are necessary to avoid injury to the religious sensitivities of adherents of that religion, provided that such acts or practices do not result to disruption of public service.
Hello?
Is that Ms. Hidalgo?
Yes, Attorney Hidalgo.
Yes, Attorney Hidalgo.
Yeah, I'm representing Alliance for the Family, and we submitted a position paper earlier. We understand that all these laws are really in everybody's interest to lean towards benevolence favor of religious beliefs. So instead of providing exceptions, why not provide instead a list of facts? We are in the exercise of religious beliefs and convictions that should be recognized anyway, right? And we need to
Which
recognize
particular
them.
we're talking about letter C.
Yeah, we're talking about exceptions, right?
Yeah. Yes.
That's the reason why I'm bringing this up, because we should recognize the right to refuse, to say, write, or do any act contrary to their religious beliefs. Because at the heart of religious freedom, to be able to act without fear or punishment, discrimination, loss of employment, demotion of work, employment benefits, coercion, or compulsion. Uh, of course, it's protected by the Constitution, but remember that the moment that this comes to a head, what to come out now would be really instead of exceptions, why not protect those who refuse to, on the ground of their beliefs, to act according to the, being asked to, for example, do things that are contrary to the religious persuasions. Because failure to recognize these rights would also be a form of discrimination as well. That's it.
Okay. So, going back, Comsec Feli, sinong authors natin ang present today?
Sir, si Kong Geraldine Roman po.
Okay. So, I would like to go back kasi we have to tackle, we're talking about this particular sections because this was submitted by the respective legislators, and I cannot amend what they submitted in its entirety without the concurrence of the proponents of the said measure.
I understand.
Okay, so I would need to go by section as I mentioned, and we're now in this item C. Are there any comments on item C?
Mr. Chair.
Yes, Alexa.
Good afternoon, Mr. Chairperson Santay. Alexa from the UPGLPP.
Yes.
So for item C, the UPGLPP actually proposes that instead of acts or practices of a body established for religious purposes, etc., we want to propose the inclusion of a standard which is already elucidated in the case of Estrada versus Escritor. So what we want to do is we want to say where the acts or practices of a body established for where the deeply held fundamental religious doctrines, dogma, or beliefs of a person or of a body established exclusively for religious purposes require or compel such person or body to perform acts or practices necessary to avoid injury to the religious sensitivities of adherents of that religion. So we propose this because the words deeply held fundamental religious doctrines, dogma, or beliefs is an ascertainable standard which is based already on Estrada versus Escritor, so that we can ascertain whether the exception being claimed is actually the deeply held fundamental religious beliefs or doctrine of a certain person claiming to apply this exception to their circumstances.
Okay, the legislator who proposed this particular section is Congressman, I believe Congressman Benny Abante, Deputy Speaker Benny Abante, and I would to such amendment. But if you could submit your proposed amendments, then we shall consider it. We shall take note of it.
Thank you very much, Mr. Chair.
Mr. Chair.
Yes.
Yes, this is from Kalin Sasuman from the Philippine Commission on Women. In our position paper, Mr. Chair, just would like to refer you to our position paper because we have a comment there, a recommendation there. For example, we recommend that the exceptions on genuine occupational qualifications and inherent requirements include the proviso stating that the exception shall be without
PCW,
prejudice. Yes,
Josephine,
sir.
can you
Yes, sir.
identify which particular line you are talking? As I mentioned, I cannot amend the proposal which has been submitted by the various legislators because if I amend it in its entirety based on your proposal, then you legislating and
That is no sir. That is just a recommendation for the consideration of the body, sir. It is already stated in our position paper, so that we have already submitted. So I would like to body the committee to refer to the position paper of PCW for consideration.
Okay.
That's all, sir. Thank you. We have a comment there and a recommendation there with regards to the section on which mentions about the genuine occupational qualifications and
Comsec Feli, can you highlight kung ano yung which particular because
and inherent requirements, sir. Thank you.
And if we
Mr. Chair.
What paragraph? Is it paragraph D?
Mr. Chair.
I think A and B about the genuine occupational qualifications, and then the next is on inherent requirement. Kindly refer to the position paper of PCW.
Okay.
Thank you.
Yes, Bishop Ruben Abante, please.
Good afternoon, Mr. Chair. Kahit ako, hindi ako makapag-comment sa bigay nung tama po kayo. We should, I think, ask the sponsors ng bill on how to word this thing. But I myself would like to comment na however nagawin natin yung terms na deeply held fundamental religious doctrines or now we are venturing into a hairline thing considering the separation of church and state. No church or religious group would want to submit yung kanilang deeply held fundamental religious doctrines to the government for their consideration. Nobody would want to do that. Who establishes that?
Can I would any of the proponents wish to answer the question of Bishop Benny?
Mr. Chair.
Yes.
If I may, since GLPP is the one who is proposing adding the clause deeply held fundamental religious beliefs. So we actually introduced this standard because most deeply held fundamental religious convictions will serve as a standard of proof to show that the belief being invoked is not purely subjective. So in fact, to address Bishop Benny's concern, I think what is needed to be proved in court is not the dogma itself or the truth behind the dogma or the religious belief, because there's no standard in any court in the Philippines which can say what religious belief is true. In fact, that is something the state does not interfere in because that's already religious establishment. So with showing this standard, what we actually want to include in the law is a standard for which the parties who are invoking the exception of of religious freedom, their burden of proof is to demonstrate not the truth behind their belief, but first, that the expression or the utterance involved or the action or conduct involved is in fact a most deeply held fundamental belief of the religion to which they belong. It must be something that is actually a fundamental doctrine of their religious group. And second, that they ascribe to such belief or dogma or doctrine with demonstrable sincerity. So not that it is just the dogma itself of the religion, but also they have to prove that they sincerely believe and they sincerely practice in their everyday life their belief in that doctrine or dogma. So I hope that clears up the confusion po.
Mr. Chair, may I just suggest that we wait for the proponents' comments?
Sir, naka-mute po kayo.
Because the proposed suggestions and amendments have been submitted, I will have to wait for the proponent to accede to such proposed changes. Okay, but the statements are duly noted. Comsec Feli, please. Where the act or mission is done in good faith for the purpose of assisting or advancing a person or group or person who need or may reasonably be supposed to need assistance or advancement in order to an equal place in society with other members of the community. Measures of equality or affirmative action program. Comments on this part, item D? Okay, we'll proceed now. E. Comsec Feli, can I know itong item E, kaninong proposal to?
That was the product of the TWG.
The TWG.
Yes, sir.
Okay, where the education and training institution and institutions of higher learning, sectarian or non-sectarian, exercise their right to academic freedom to determine and implement school policies on the proper decorum and behavior that are consistent with their respective mission, vision, and objectives, and do not violate any of the rights provided under the Constitution. If I remember correctly, this is similar to the provision which we earlier discussed during the last committee hearing. So nilagay lang natin ulit yan.
Sir, Commissioner Karen is raising her hand.
Yes, Commissioner
Karen Dumpito.
Okay.
Good afternoon, Your Honor. Just to be able to convey our thoughts on this, we would like to be able to make a distinction between sectarian and non-sectarian schools. So the rewording we propose is where sectarian educational and training institutions and institutions of higher learning, ... Let me just explain that a bit, Your Honor. So on gender expression, for instance, and academic freedom, the Commission recognizes the right of sectarian schools in imposing reasonable rules in accordance with academic freedom. However, we just want to convey that in our situationer of LGBTI children, it has shown how restrictions and discrimination based on gender expression has impacted student education, well-being, and mental health. and how this has caused students from dropping out of schools. With this, we request, of course, the committee to reconsider this exception based on academic freedom and, if possible, to allow such leeway only for sectarian institutions. And with this proposal, it can be made clear that non-sectarian and public educational institutions cannot adopt policies that discriminate based on a student's gender expression. Yun po. And then just to be able to convey, sir, meron lang pong bilin yung mga partners namin na LGBTI groups, and they wanted me to say this to all of you. They just said that we request and we reiterate that LGBTIQ groups be invited and be allowed to speak as well. They feel that they have not been allowed to participate fully. No?
You know, Commissioner Karen, in fact, this has been the most exhaustive deliberations on this particular matter. I did not only call, alam nyo ho, pagkatapos ng deliberation sa TWG, hindi na nila line by line ulit yung pag-uusap dito. And if you're asking that I recall again certain individuals and go back to square one, then we are doing this particular measure more disservice talaga aabot dito. As we all know, once this particular Congress adjourns or is finished and the elections come up, this particular measure will not see the light of day and it will have to be refiled again.
I will convey that, Your Honor. I just wanted to keep my word to our constituency that I will also convey that feeling
Yes.
that pero ibabalik ko rin
Yes,
po sa
Commissioner
kanila.
Karen. Kasi if we do not finish this, then we are doing those individuals relying on this particular measure more disservice dahil we are pressed for time.
Yes, Your Honor. Thank you for that opportunity to be able to convey that, Your Honor.
But with regards to your proposal on distinguishing the exclusion between sectarian and non-sectarian, yes, it is duly noted, and I will make sure that would consider it seriously.
Thank you, Your Honor.
Okay, we proceed. Section 9. Okay, I think with regards to person liable, yes, Commissioner Karen, are you raising your hand? No. Okay.
Your Honor.
Yes, Alexa.
Thank you, Your Honor. For Section 9, the UPG-LTP would like to introduce a proposal for the consideration of the proponents of the bill and the Committee on Human Rights. So after the first sentence in the second paragraph, we would like to include the words, any person's failure to act which resulted in the discrimination of another shall be punishable as discrimination under this act. So we would like to propose this because failure to act or negligence or one's omission on matters involving discrimination must be included because such may result in the discrimination of another. Furthermore, we have observed that...
Wait, Alexa, so that we tayo one at a time. Yung muna, yung proposal, Comsec Feli, can you have the same type kung saan ilalagay?
Yes, sir. We will copy from the chat box, sir.
Yeah, total, it's medyo germane to the other. I believe, I would like to believe that the proponent of the measure would be willing to accept it.
May we explain our further rationalization for the inclusion of this?
Sandali lang pa-type lang natin, Alexa, then a chance to explain.
Thank you, Your Honor.
Now ito, with regards to your proposal, any person's failure to act which resulted in a discrimination shall be punishable as discrimination under this act. But what if it is not that person's responsibility to act? Then why will we make him liable? There be a connection between the actor and the action to be taken before we make them.
Mr. Chair, so our rationale for this is because the provision itself seems to distinguish between what kinds of perpetrators are being held liable. So from our interpretation in paragraph 1, this pertains to the actual perpetrator or the principal by direct participation.
Yeah,
While
but
in paragraph 2,
you asked it to be placed in paragraph 2. So this particular sentence would pertain to the contents of paragraph 2, not of paragraph 1.
Yes po. In connection with paragraph 1 naman po, our observation in paragraph 2 is it applies to persons who assisted the perpetrator or contributed to the commission. So it could pertain to the principal by inducement or indispensable cooperation. We would like to include, therefore, a failure to act because this would constitute an omission on the part of someone.
I understand. I understand why you want to include yung the failure to act. But as I mentioned, look at the last paragraph. Nilagay natin dyan. Any person who is duty bound to act on complaints of discrimination under this act but fails or delay shall be deemed prima facie to have sanctioned the discriminatory act. So we pointed out that that particular person is duty bound to act on the complaint. Kaya nga sinasabi ko, if we just put here any person's failure to act which resulted in the discrimination of another shall be punishable as discrimination under this act. Kunyari, if he is not duty bound to act, kunyari, meron sa restaurant, there are 2 customers, tapos nun, merong gustong, for example, LGBTQ, gusto gumamit ng CR ng pang babae. Tapos nun, narinig nung isang. Tapos doon yung waiter sinabi hindi pwede. Tapos yung customer nandun walang sinabi o hindi sinabi doon sa waiter, hindi, paggamit mo na. Then, would he be liable for failing to for discrimination under this act, for failing to stand up for the right of the who wants to use the toilet, di ba? He should be duty bound to act. Hindi pwedeng any person's failure to act lang. If he's not duty bound to act, then why will he be made liable?
Yes, Your Honor. We understand the observation. In our proposal, the context here is that if a person has the capacity to prevent the discrimination pursuant to, for example, a lawful order by the person,
but that would be too long. The law should be concise. We have to make it specific to avoid wrong construction of the same. It cannot be so vague as to be subject to various interpretations.
For that,
if you want to propose the inclusion of that particular sentence, then you have to make it which person shall be made liable.
Opo. For that po, Your Honor, we observe as well kasi po in the third sentence, it says duty bound to act on complaints of discrimination. So we wanted to include within the liability in paragraph 2 those persons who are not duty bound to act on complaints of discrimination.
Then we cannot do that. We cannot do that. If he's not duty bound to act on complaints, why make him liable just because he didn't act on the complaint if he's not duty bound to act on it, di ba?
From our interpretation po kasi when we say duty bound to act on complaints,
that's your interpretation. That's your interpretation. And kung tayo lang dito, dalawa lang tayo nag-uusap, naku-confuse na tayo, what more kung if this becomes a law? So might as well make it specific. Ako, I'm willing to include it and defend the inclusion, but it has to be more specific. It cannot be too broad as to be subject to different constructions or interpretation. So kung pwedeng maging mo, any person's failure to act when it is his responsibility or duty to act, you have to make a distinction. Okay? So pag-isipan mong mabuti, Alex, once na you are able to rephrase it properly by identifying who the person is and his obligation to act, then we will include it. But it's very hard to accept pag as it is yung proposal mo, pagka any person's failure to act lang which resulted in the discrimination of another shall be punishable as discrimination under this okay, we proceed with section 10. Then once you rephrased it, you just call my attention, please.
Thank you, Your Honor.
10 up, lumampas ka na. Creation of a Non-Discrimination and Equal Opportunities Committee. Okay, this is a creation of the Non-Discrimination Committee to an Equal Opportunities Committee to take cognizance of compliance with of this particular bill. Malagay ko naman wala masyadong issue dyan. Ayan, we go? The Non-Discrimination Committee shall, among others, conduct the initial investigation of cases constitute discrimination on the basis of actual or perceived ethnicity, race, color, sex, gender, ethnicity, race, color. Parang naging redundant. Comsec Feli, pakiayos yan. Dalawang beses natin inulit yung race, color, sex. Pati yung sama may ethnicity in front. Ayan, okay. Okay, comment on this particular paragraph? Okay, if we...
Mr. Chair, may we be acknowledged?
Yes, Alexa.
Thank you, Mr. Chair. Your Honor, for this, the UPGLPP wants to propose that instead of the appropriate government agencies, we should replace this with the appropriate disciplinary bodies, because we wanted to establish non-discrimination committees both in the public and private sector. So if we limit appropriate government agencies only to the government, then it might lend confusion to the public that they cannot go to the disciplinary bodies of a private institution or corporation.
Yung problema dito, Alexa, the Non-Discrimination Committee, yan na yung yan yung tinatayo ng private institution. So, but of course, while they could implement their own disciplinary action, if they want to raise it to the government level so that the government could also take jurisdiction over the same, it has to be the appropriate agency. Because kung nasa lang natin na appropriate, what were you saying? Appropriate...
Or appropriate sanctions.
Hindi. Yung you didn't want the government agency, appropriate what body ang but the appropriate disciplinary body is just private parang yan na nga yung
Yes po, Your Honor. For this, Your Honor, we understand po meron naman po talagang administrative remedy in the quasi-judicial agencies who have jurisdiction over the dispute. But we want to clarify here that, for example, in a workplace setting, there is a grievance machinery where a non-discrimination committee might be the one who has the jurisdiction to act on complaints of discrimination before it can get to the appropriate quasi-judicial agency. So in that case, we wanted to make it clear first that appropriate disciplinary bodies of the agency, corporation, company, and educational institution, and imposition of appropriate sanctions by such institutions is also a viable remedy before going to the court, before going to the administrative level po.
Sanay lang ah. Yeah, but alam mo, the thing that you want to achieve is in the on the fifth paragraph. Go down, then ano rin yan it indicates any administrative sanctions on the perpetrator or discrimination shall not be a bar to any prosecution in the proper courts. So it presupposes that the company, the private entity, the private company, after imposing, is empowered to impose their own disciplinary actions even without putting it there. Ang gusto lang natin na it does not serve as a bar yung the imposition of yung administrative sanction by a private entity's a committee or a grievance committee shall not serve as a bar for elevating it to to the national the pertinent government agencies. So so NCIP, ano ba, NCIP? Sino yung sa NCIP?
Yes, sir.
Yes, ano yung proposal mo? Which particular paragraph?
On the fourth paragraph, sir, just our rewording kasi parang nag-iba po kayong context ng wording.
Sige, how do you want to reword it?
Yan po, sir, as provided in the chat, it to be amended as follows. In instances where complaints of discrimination of ICCIPs.
In instances where discrimination, Comsec Feli, can you, I think it's in line 13. Up. Ito.
Line 18.
Instances where discrimination complaints against ICC's IPs are first filed with another entity. Same complaints may be referred to the NCIP for conduct of appropriate investigation. Based on its findings, the NCIP shall initiate the filing of appropriate legal or administrative action to the appropriate officer or tribunal and may case for and in behalf of the ICC-IP, subject to existing rules and guidelines in the prosecution of criminal cases.
Yes, sir. Sa line, yung first line lang po, line 18. Kasi parang yung complaint po is against the ICC's IPs. Construction niya. So we propose the rewording lang po. Yes po, sir.
How do you want it reworded?
To be reworded as in instances where complaints of discrimination of ICC's IPs. Yun lang po.
Okay, Comsec Feli, take note please.
The same would be applied in the following section po, section 16. We'll just post.
Let's wait for yung secretary to finish para hindi malito.
Okay. In instances where complaints of discrimination
Of
of
discrimination.
discrimination of ICC's IPs.
After discrimination, put off after discrimination. Complaints of discriminations.
Of ICC's IPs.
Hindi, wag yata off. Baka from ICC's IPs are first filed. So, ganyan ba yung gusto mo? Yung proposal mo na rewording?
We propose of po, sir, discrimination of
Off.
ICC's.
Okay, instead of from, off raw yung proposal nila.
Yes po, sir. Thank you. Thank you, Chair.
Ito, grammatical lang yung after entity, same complaints, parang parang may kulang. Or first filed with another entity, put the before same and then tanggalin yung S sa complaints. Okay, let's proceed. Duty of the Commission on Human Rights. Meron ba tayong rep ng CHR dito?
Yes, Your Honor.
Yun, Commissioner Karen, comment. Total sa inyo yan.
Good, we're good with it as it is, but we'd like to just add one,
Okay.
Your Honor. To just be able to also include provisions that would allow us to create a unit within the commission to undertake all the activities with this, because kulang din po kami sa tao.
I
And
understand. So, how do you want it placed?
in the regional offices. So maybe creation of a non-discrimination or equal opportunities office, division, or unit within the National Office of CHR.
Okay, we'll include it dun sa enumeration.
Opo. Maybe that's the first. And also a desk for the regional offices.
Okay,
All regional offices.
Commissioner Karen, can you word that particular paragraph and then send it to Comsec Feli, to the Secretary?
Yes, Your Honor, we will.
We'll include it in the enumeration. Okay?
Yes, Your Honor. Thank you.
Your Honor.
Yes.
This is still in section 10. We just have a clarification. Does the current version of the law have any sanctions in the failure to establish a non-discrimination committee or failure to act on a complaint?
Yes, pagdating natin sa penalty clause, doon mo makikita.
Okay.
Okay.
Thank you, Your Honor.
Welcome. Okay, 12. Responsibility to promote a non-discrimination and equal opportunity environment.
Mr. Chair?
Yes.
Yes, Yama po. Pwede pakibalik muna sa section 10, Mr. Chair? Sa line 8.
Okay.
May ano din ako, may mungkahi lang ako, Mr. Chair.
Basta
Number
ikaw.
10.
Line.
Line 8, Mr. Chair.
So, please go down. Yan, line. Dito. Diyan ba?
Asa man nilapit, Mitch? Doon sa, however, pieces of complaint of facts. Taas pa, Mr.
Lagay
Chair.
mo sa ICC. Baka sa baba.
Yes, ayan. Okay. Okay. May mungkahi ako dyan, Mr. Chair. Baka no? Mungkahi po na Sa CHR na ibigay ang pag-imbestiga sa lahat ng mga kaso o reklamo ng discrimination laban sa katutubo upang matiyak ang independent body ang magsagawa ng investigasyon sa mga isinampang reklamo, Mr. Chair.
So ang gusto
CHR.
natin ng NCIP?
Opo, Mr. Chair.
Oh, sandali lang please, 5 minutes. Can I have a 2-minute recess lang? One moment. Kong Femi, ano yung proposal mo? Tanggalin natin yung NCIP?
Opo, CHR lang ang CHR lang ibigay
CHR lang.
Ang bigay ng mag-imbestiga sa lahat ng mga kaso o reklamo.
NCIP, may rep bang NCIP dito?
Yes, sir. Si Ms. Dinuan, sir. Attorney Dinuan.
Attorney Dinuan, there is a proposal na ibigay na lang yung sole jurisdiction with the CHR. Ano po masasabi niyo dito?
Based po on our position paper, sir, that was signed by our commissioner that went through our commission and bank, it is the proposal that for cases involving discrimination of IPs, the NCIP may also investigate these complaints. So the complainant may so choose whether sa CHR or sa NCIP. And one of our reasons is that may mga regional offices din po kasi kami sa baba and other field offices na malapit sa IP communities wherein they can file directly their complaints po. So that is the position of our office, sir.
Ayan. Kong Euphemia, bakit gusto mong tanggalin yung NCIP? Wala ka bang tiwala sa kanila?
Ano lang po, Mr. Chair, yung ano lang, para may independent ang investigasyon na magaganap. Yun lang po, Mr. Chair.
Okay. Thank you very much. I will have to raise this with the proponents. Kong Femi, on whether to delete it or not. Okay?
Okay. Okay, Mr. Chair, maraming salamat.
Your Honor.
Yes, Alexa.
Regarding the jurisdiction of the CHR and the NCIP, may we clarify if cases or complaints of acts of discrimination have to go through the CHR before they can be filed before the appropriate government body? Because as we understand, the commissioner of the CHR may correct me on this if I am making a mistake, but based on our understanding, the CHR doesn't have the prosecutorial power like the DOJ to file the case in court, but they can undertake the investigation of the acts of discrimination. Is that right po?
If I may respond, Your Honor. Yes, that's correct. No, we don't have prosecutorial powers unless this law will give us one. But we do investigate. We can investigate on our own. So as Representative Koyamat has said earlier on, it's an independent investigation. It will be a human rights investigation as opposed to a criminal or administrative investigation. So it can run parallel.
Mr. Chair, may I be recognized?
Yes, Alexa.
With that po, we would just like to express some concern as to the possible confusion as to the appropriate remedy in this case, because the law seems to say that the jurisdiction is with the Commission on Human Rights, but we have to clarify that victim of discrimination always has a direct resort either to the quasi-judicial body that is vested with jurisdiction to act on the complaint or to the courts for civil or criminal complaints.
Yeah, but Alexa, it does not preclude the discriminated party from filing directly. Ang lalagay lang natin dito, yung authority ni CHR is that they can motu proprio investigation of acts of discrimination. But it doesn't, there is nothing in the law that states na they have to go to the CHR first before they could file it in the proper courts of jurisdiction. Mm-hmm. Wording lang, Comsec Feli, pakitanggal yung sa investigate. As the case may be, investigate motu proprio. Tanggalin na yung may, masyadong redundant, sumobra namin, yes. Okay, let's go back. Baba na tayo. Balik na tayo sa sa CHR. Yeah. 12, responsibility to promote a non-discrimination opportunity environment.
Pahamot raw ng NCIP.
Okay, go down. Palagay ko wala namang issue dito. There's an enumeration here. Social Protection Program. The national government shall implement social protection measures for communities affected by any vulnerable to stigma and discrimination. B, diversity and inclusion, programs and policies. All government agencies, government-owned and controlled corporations, private companies, public and private educational institutions, and other entities shall establish diversity programs to ensure that the discrimination and abuse prevented. They shall also create an internal redress mechanism to address cases of discrimination and grant administrative remedies or sanction for such cases. Okay, C. All government officers and workers are obliged to promote non-discrimination in the discharge of their duties and responsibilities. Palagay ko, hindi naman contentious yan. Sige, let's proceed. Section 13. Okay, but before that, I would like to acknowledge the presence of Congresswoman Precious Hipolito from the district. The most beautiful Congresswoman of Quezon City. And of course, Congressman Onyx Crisologo of the 1st District. Comments on Section 13? Okay, kung walang comment dito sa Section 13, can we proceed? Section 14? Alexa, ito na yung hinahanap mo, yung penalties. Okay, then A, graduating yung penalty natin. Okay, C. Okay, D. E. Okay. Okay, please go down. Next paragraph. Comsec Feli, may inimbita ba tayong tiga Bureau of Immigration?
Sir, wala po.
Pwede ba yon yung deportation, immediate deportation? Without without any other proceedings? Pwede ba yung gawin yun? Di ba may human rights rin yung foreigners? Commissioner Karen, anong masasabi mo dyan?
I'm not aware of any particular rule, Your Honor, pero I think nangyayari din yung summary deportation eh.
Nangyayari rin,
Maybe we can confer already with the Bureau of Immigration to be more precise, Your Honor. I'm not really sure.
Thank you. Comsec Feli, ano lang natin just to make sure kung pwedeng summary deportation yung
Yes, sir. We will ask for their position on that.
Thank you. Let's go down. Next paragraph.
Mr. Chair.
Yes, Alexa.
Your Honor, may
Bakit wala ka na sa Hindi na kita makita.
Thank you for calling my attention, Your Honor. My camera was off po. We would just like to point out po that the GLPP believes it is prudent to increase the penalty of the Comprehensive Anti-Discrimination Bill. Since right now po the penalty is 30 days or more than 6 months. So it's just arresto mayor or imprisonment for that period. We are proposing to apply the penalty imposable under the Philippine HIV and AIDS Policy Act for commission of discriminatory practices under that law. So in RA 11166 po, the imposable penalty is imprisonment of 6 months to 5 years and or a fine of not less than 50,000 but not more than 500,000 at the discretion of the court po.
Okay, Comsec Feli, for purposes of consistency in the imposition of penalties, we will consider yung proposal ng UP GLPP at gagawin na natin. Pag gusto mo?
We have sent it in the chat.
Yes, we'll follow it.
Thank you, Your Honor. We leave this up to the wisdom of the committee po.
Yes, we'll follow it. Thank you very much for that suggestion, Alexa. Okay, Section 16, Administrative Proceedings and Sanctions.
Sir, Attorney Dunuan is raising her hand.
Yes, Attorney
Dunuan.
Yes, sir. In line 19 to 20, the same po, just a rewording.
Okay.
Line. In the exercise of their monitoring functions and upon finding by the CHR or the NCIP, in cases of discrimination of ICIPs.
In cases of discriminations or complaints filed, instead of against, dapat siguro by ICCIPs. Ano ba?
That would be okay in cases.
Yeah.
Okay.
Filed by.
Filed
Diba?
by.
Tanggalin yung against.
Yes,
No, yung against, tanggalin yung against. Lagay
Thank you, Chair.
Welcome. Okay, next paragraph. Reparation of victims. In addition to existing laws and procedural rules for reparation to victims, the following measures shall be undertaken by the body principles relating to reparations to or in respect of victims, including restitution, compensation, rehabilitation, guarantees of non-repetition, and public apologies in their decisions. The court administrative agencies or quasi-judicial body may either upon request or in their own volition in exceptional circumstances determine the scope of the damage, loss, or injury to the victims, stating therein the principles on which they are acting. Okay, palagay ko wala naman issue dyan. B. Okay, C. Okay. Section 18.
Mr. Chair.
Yes, Alexa.
Thank you, Your Honor. So for letter B, I'm sorry po, but this is section 17, letter B. So
Section 17.
we just point out po that the wording now is may, and we propose that instead of may, it should say shall, so that it is more it's more authoritative than may.
Okay.
And then also po, can the GLPP would like to propose an additional clause in this section where the DSWD shall provide rehabilitative counseling and treatment to perpetrators towards the understanding of human rights. When necessary, the offender shall be ordered by the court to submit to psychiatric treatment or confinement.
So yung may gawing shall, and then add another paragraph. D.
After letter C na lang po.
Yeah, after letter C, D. There is a proposal from UPGLPP with regards to yung rehabilitation WD.
Your Honor, this proposal is based on the anti-vowsy.
Yes.
Opo. Thank you po.
Okay. So, concept Feli, iano na lang yan ha. Kahit later on na. Kasi, ayan. Okay.
Yes, sir.
Okay, 18. Yung grammatical lang, after yung where, tanggalin yung A. Sorry. Where a prima facie finding by any court, tanggalin mo na yung where there is. Ayan, where a prima facie finding by any court or other competent authority that discrimination has been committed against any person for no proof of breach on the right of equality committed against the complainant rests on the respondent. Okay. 19. CHR, meron pa ba kayong pera para dito?
Appropriations would be most welcome, Your Honor. So instead of just perhaps the chairperson, the CHR shall include. Because as you know, we're a collegial body. So the CHR shall include in its program the implementation of initial
Tanggalin,
funding.
yeah, so Secretary, tanggalin mo yung chairperson off. So it should be the CHR shall include. Tama? Commissioner Karen? Yeah.
Yes, Your Honor.
Okay, thank you.
In its program, instead of the CHR's program, in its program, the
In its program. In its
program.
Yan.
Walang apostrophe yung its.
Okay. 20. Implementing rules.
Your Honor.
Sino yun?
GLPP po.
Okay, Alexa.
Your Honor, can we just inquire about the viability of establishing an anti-discrimination oversight committee as well as an interagency council? Because I think this was also brought up by Commissioner Gomez of the CHR due to the logistical challenges posed by implementing this law. We would just like to ask if it is feasible to establish perhaps an interagency council on non-discrimination and equal opportunity with the involvement of other government agencies po.
Okay. Kindly submit your proposal dahil that's another subject matter which I would need consent of the various authors before I do it. Huh?
Sige po. May we then reserve our right to submit our proposals in a separate position
Yes,
paper
please do so.
regarding the administrative provisions po of this law.
Okay.
Sige po. Thank you very much, Your Honor.
Thank you, Alexa. Section 20.
Your Honor, may I just...
Yes, Commissioner Karen.
Yes, thank you very much. Just to be able to agree with GLPP on the matter and maybe to take into context that particular proposal within a provision of monitoring compliance of the Act, and possibly that interagency could also be regarded as an oversight committee that will periodically oversee the implementation of that. So we will give our formulation, Your Honor, also on that.
Yes, kindly submit the same so that we could have it considered. Okay?
Thank you.
Take note mo lang na there is a proposal for a creation of an oversight committee. Okay? Implementing rules lang yan. Tapos doon, Section 21 is the separability clause, repealing clause, and effectivity. So I believe that's it.
Your Honor.
Yes, Alexa.
For ano naman po, minor na lang naman po ito. For the repealing clause po, can we include the words all laws, decrees, orders, rules, and regulations or parts thereof, rather than just any provision of law or regulations po, so that it's comprehensive? Kasi
all laws, decrees, executive orders, memorandum, order.
Sorry.
Or parts thereof.
Yes, I think magkaiba po tayo ng nakitang copy. But yes,
Okay.
yun po essentially.
Okay.
Also, on the IRR po, can we clarify po if there is a clause in the provision on the IRR that says that within a certain period of time from the effectivity of the act, the IRR should have already been promulgated by the appropriate body?
Ayan nakalagay within 60 days.
Okay po. Thank you very much, Your Honor.
Okay, so with
Mr. Chair,
yes,
just one last, I apologize that I overlooked this earlier. Maybe I went out a bit. Regarding the provision on diversity programs, I think this is section 12. Be formulated in reference to the existing mechanisms under EO 100. which is institutionalizing the diversity and inclusion program, creating an interagency committee on diversity and inclusion for other
Josephine,
purposes.
which particular section para masundan?
12, sir. Mr. Chair, it's section 12. I really apologize that I missed out this. Maybe I was out.
Responsibility to promote a non-discrimination.
About, yeah, on the diversity programs and policies.
Comsec Feli, can you highlight section?
That is also included in our position paper, sir. So the committee can just refer to our position paper.
Ano na natin ngayon, ayusin natin ngayon. Which particular paragraph are you?
It's section 12.
This is section 12. We've highlighted.
About the programs.
Second paragraph. The state shall endeavor to eliminate all forms of discrimination and shall therefore pursue initiatives and programs that seek to enable an environment free of stigma and discrimination. Ano yung suggestion?
The formulation shall be formulated and reference to the existing mechanisms under EO 100 on institutionalizing the diversity and inclusion program, creating an interagency committee on diversity and inclusion, and for other purposes.
Yeah, but this particular provision said this particular section does not only tackle diversity and inclusion. There's also a social protection program.
Okay, sir.
Oo, pagka ilalagay natin yun, then it will not...
Just for a review of the committees or consideration lang naman po if you want to, if you see it relevant.
Sige.
Thank you so much, Mr. Chair. Thank you.
Okay, so I believe that's it. Thank you. Can I have a motion now from the proponent? Andyan pa ba si Kong Geraldine? Comsec Feli, wala na ba yung proponent natin?
Wala na po, sir.
Naku, tagal-tagal niyang
Naglaga.
Sino magmumove?
Wala na pong ibang authors po.
Si Kong Femi. Kong Femi, andyan ka pa? Kong Femi, ha?
Wala na, mga resource persons na lang karamihan, sir.
Wala nang author? Maraming salamat sa inyo. Unfortunately, I cannot approve the bill, the proposed measure, without the authors moving for it. So, Comsec Feli, pakisabi na lang sa kanila na natapos na yung discussion. We'll just set another hearing for this a motion to approve the same. Unless, nakikita ko pa si Rep. Femia. Baka may text mo siya.
Wait lang po, sir.
Para matapos na ito, and then we will just consider go back to yung mga different proposals which we noted and was raised earlier.
Sir, wait lang daw po, sabi po ng staff ni Kong Roman. If you
Tagal-tagal niyang hinahanap to, tapos wala na siya. Well, while waiting for Congressman, I would like to thank all our resource persons who have taken part in deliberating this measure. I know it has been a very exhaustive, tedious process. Kagaya ng sinabi ko, usually pagka in-approve ng TWG, alam niyo, pagka sinubmit sa Mother Committee ulit, motion to approve na ulit, but I tackle things differently in my committee, and we after the TWG, I like to go over the provisions one by one.
What? Yeah. What is this?
Yes, Kong Geraldine. I just need the motion to approve.
Yes. Mr. Chair, I move that we approve this version that we are discussing right now.
Okay, there is a motion to approve consolidated House Bill. Hearing no objection, subject to amendments which were raised earlier. Hearing no objection, the same is hereby approved by this committee. So, maraming salamat.
Congratulations, everyone. Thank you very much, Mr. Chair.
Congratulations, Kong Geraldine. Once again, very much, Alexa. Thank you very much. We appreciate all your suggestions. Okay?
Thank you very much, Your
And
Honor.
of course, Commissioner Karen Dumpit.
Thank you.
Bisa Rubino has always been present. Oo. Thank you very much sa inyong lahat. Maraming salamat sa inyo.
Yes.
Sec Feli, salamat. Yes?
Mr. Chair, naalala ko.
Yes, sir.
Hindi lang po nabalikan yung glossary. Pero okay na yun.
Sige.
Takon tayo dating glossary, di ba?
Yes, oo. Di bali na, pagka nasa plenary na, we'll include it. Thank you, Kong Femia. Maraming salamat din sa iyo. Hinahanap.
Maraming salamat.
Sige. Thank you. Thank you sa inyo lahat.